Hey gang, Stephen Marshall, KYLandlordlaw.com, back with another update. And there's been a lot that's gone on since my last update, so let's jump right in. And I want to start with a quick reminder that starting on April the 1st, the Kentucky Supreme Court is allowing evictions to proceed without regard to CARES Act status. So practically that means two things for us. First, you no longer need to file a verification of compliance form with your evictions, which means you don't have to look up your property in those loan databases anymore to find out if you're covered by the CARES Act, because the Supreme Court no longer cares. And then second, you can go back to giving your usual notice. So if you're in a URLTA area, you give a 7-day notice unless your lease requires more than that. If you're not in a URLTA area, you're going to give whatever notice your lease requires. Now, if your lease doesn't say how much notice to give, your local district court still may require 30 days. So be looking at your lease if you're not in a Landlord-Tenant Act jurisdiction. So on to the new stuff. Yesterday we learned to no one's surprise, the CDC extended its eviction moratorium through June 30th of this year. Earlier, as you probably know, President Biden had wanted it extended through September the 30th. Congress did not do that, and so the CDC yesterday, on March 29th, extended it through June 30th of this year. But there have been some updates in the litigation surrounding the CDC moratorium. In my last update, I told you about how a federal district court in eastern Texas ruled that the CDC had no constitutional authority for the moratorium. Well, you can now add 2 more strikes on that list. Federal courts in the Northern District of Ohio and the Western District of Tennessee both found that the CDC exceeded its constitutional authority in enacting an eviction ban. And that's totally intuitive, right? It makes no sense that an agency whose job is to deal with public health would be meddling in private housing relationships. So it makes sense that they wouldn't have constitutional authority to do that. You can read the opinions from the Ohio court and the Tennessee court in the blog post that's going to accompany this video. But there's interesting implications for us in each case. First, in the Ohio case, one of the parties that was a plaintiff in the case was the National Association of Home Builders. They brought the case as a representative on behalf of all of their members. And the result is that the court's ruling in that case sets aside the moratorium for every one of the home builders' members. So if you're an NAHB member, you need to present this fact to the local court during any eviction in which your tenant claims CDC protection. Because as it pertains to you, the CDC moratorium has been set aside by the federal court in Ohio. Now, the Tennessee case also potentially has some implications for us. After the trial court ruled for the landlords in that case, the governor asked the Sixth Circuit Court of Appeals to stay the judgment until they could appeal the ruling. In response, the Sixth Circuit denied the government's motion because it did not believe they could prevail on appeal, and that's one of the bases that has to exist in order to stay the judgment. And the Sixth Circuit basically said, we don't think you can win on appeal. And so the implication is that they've tipped their hand to us, that they are not going to overturn this lower court ruling that the CDC eviction moratorium is unconstitutional. Well, the reason that impacts us is because the Sixth Circuit Court of Appeals covers Kentucky. Okay, it's where cases go that are in federal district court in Kentucky. If they get appealed, they go to the Sixth Circuit. And that means that any landlord in Kentucky that seeks to invalidate the CDC moratorium in federal court and wins, that win is likely going to be upheld by the Sixth Circuit. Now we just need somebody to bring the case. Or we need the Tennessee case to be amended to have some injunctive relief. So potential big implications for us in Kentucky that the Sixth Circuit Federal Court of Appeals does not believe that there's a constitutional basis for the CDC moratorium. So good news there. And then finally, another bit of good news, Senate Bill 11. I mentioned this in an update earlier this year. That's the bill that prohibits damage to residential rental property by tenants. It actually makes that a criminal offense. This bill easily passed both legislative houses, and unfortunately, as I warned, the governor did veto it. And he issued a written statement on the veto that he did it because it purposely targets tenants during a pandemic despite their need to be healthy at home. Now, respectfully, that makes no sense. The bill does not target innocent tenants. It targets only tenants who wantonly or intentionally deface, damage, or destroy a residential rental unit. And I think we'd all agree that those tenants need to be targeted for that behavior. And it's shocking to me that the governor would not agree. The good news is that despite the governor's veto, his veto has been overridden by the legislature. And so you can expect Senate Bill 11 to become law later on this year. So that's good news for landlords. So that's a lot going on here as we roll into April. So as things get updated, obviously I'll be back with more information. But good news so far. The CARES Act is gone. The CDC is taking hits in litigation everywhere that we turn, and the noose is kind of tightening in this area. And Senate Bill 11 is going to be law in 2021. So that's my update for today. I hope you guys are doing well and having a fantastic start to your spring. If you have any questions or need my help, I'm at 859-685-0035 or by email smarshall@trippleslaw.com. Hope you're doing well. We'll talk soon.